markets, having pioneered the regulatory structuring of several landmark ethical investment funds at the first community bank, which is now the premier bank in Kenya. She's a practitioner scholar. She's currently a PhD candidate at the University of Namibia, where her research focuses on the legal frictions between regional and continental trade laws under the AfCFTA. And through her boutique firm, Palm Investments, she bridges the gap between regulatory theory and market practice, building foundations of the African trade through strategic consultancy and real estate advisory. Now, wait no further, ladies and gentlemen. Our able moderator is the one and only Miss Patricia Mutiso, who also doubles as our chairperson of the East Africa Law Society Capital Markets and Securities Committee. Good afternoon, Patricia. It's good once again to host you with your eminent panel of experts, and we look forward to a very wonderful session under your able stewardship from now till the hour of 4. Friends, we are streaming live on YouTube as well, so please, you can also catch us live on YouTube at East Africa Law Society. Patricia, over to you.
Thank you very much, Gabriel. Thank you to the Secretariat for having us. Good afternoon, panelists. Good afternoon, dear friends and colleagues in East Africa. Thank you for coming to join us for today's session, which is titled Inside Capital Markets, How Security Law Really Works in Practice. The session is being recorded. We welcome your questions. Please submit them using the Q&A button at the bottom of your screen, and all the panelists will be able to confidently address them. So with regard to our topic, we learn about securities law through statutes, case studies, and textbook scenarios. The what of the regulation, that is what we call it. But in 2026, the capital market is moving at a very exponential speed. Yeah, and the practical application of these laws is far more dynamic, nuanced, and fast-paced than the textbooks suggest. The East African region, the East African community, which is one of the fastest growing regional economic communities in Africa, is growing at a very fast pace. And that's why today we are going to listen to all the panelists as they represent and talk about the different topics, from IPOs to regulatory sandboxes to what is the future of capital markets. So to start this conversation, we are going to pull back the curtain and look at the exceptional panel of experts that we have today. And over the next 2 hours, we are going to cover several topics. So without further ado, I will turn it over to my panelists. And the first panelist to speak is going to be our representative from the regulators, and her name is Alison Kwirikiza Serukaka. And she's a governance professional, an in-house practitioner with extensive in-house practice experience in corporate and commercial law, securities law, and regulatory affairs, obtained in both the private sector and public sector, spanning the last 10 years. She works with the Capital Markets Authority, and she's the manager for legal and board affairs in the Directorate of Legal and Board Affairs, which is a custodian of the authority's legal framework. She's responsible for providing legal advisory to the authority and board secretarial roles. She's also a member of the Quality Assurance Board of the Institute of the Certified Public Accountants in Uganda. She's a member of the Uganda Law Society, the East Africa Law Society, where she serves as the ELS In-House Council Committee and the ELS Capital Markets Committee. Welcome, Alison. Take this away. So Alison will be speaking to us today as a regulator, so you better listen very well if you want to be in the capital space, because she's going to be speaking about from law to the market and how security regulation really works in practice. It's just not the theory. She will tell us how they practically look at it, and she'll address this. So welcome, Ms. Alison Kwirikiza.
Thank you, Patricia, for that kind introduction. I don't come with a stick as a regulator. Hopefully I come as part of the society to share my insights on this very critical topic that has been selected. But good afternoon to everyone on the call. It's always a pleasure being a part of this conversation, whether as a panelist or as a member of the audience. It's always a good learning point.
Because he's fined again after those.
Okay, thank you. So as requested, I'll be sharing insights on the practical application of regulatory frameworks in the capital market space. Patricia, I've had the benefit of being both a market player, so a regulated party, to a quasi-regulated party, a frontline regulator when I worked at the Securities Exchange, and now to a regulator. So I can safely say I have a 360 view of the application of the law in the market, and hopefully I'll be able to share those experiences that demonstrate securities regulation beyond just the text of a statute and how it actually comes to life when it comes to transactions, how they are approved, how commercial realities shape interpretation, and a few insights on the challenges that we face as regulators and as market participants. And I want to believe that most of these challenges and realities cut across our 4-5 jurisdictions because our market realities are not so far off from each other in terms of products, in terms of investor types, and when you look at the socioeconomic context that drive the market. But to start this conversation, I want to pose a sort of rhetoric question. Why regulate securities transactions? Why does securities regulation matter? I think as lawyers, we often tend to be preoccupied with the text, the due diligence, of course, guiding the client, making sure that your work represents the fee note that you send at the end of the day. Granted, that is very important. Maybe it's an IPO, or it's an acquisition or a merger, or you could be navigating routine compliance management issues. But do we stop and ask ourselves, why are we doing this? For whose benefit? Who is the market? And for me, the simple answer is the investor. The investor is why the market exists, and securities regulation is the backbone of keeping that investor's confidence at a level where it can facilitate market functionality. Now, the International Organization of Securities Commission organization, that is IASCO as an acronym, has issued 3 core objectives for securities regulation. Number 1 is protection of investors. Number 2, as an overall objective of securities regulation, is managing systemic risk. And number 3 is ensuring a fair, efficient, and transparent market. So those are the parameters within which securities regulation is developed, and it cuts across various jurisdictions, including our region, because the IASCO is a global standard setter and it has over 200 jurisdictions that participate or subscribe to the organization, and their standards really shape the development of our regulatory framework as securities markets. Now, for nascent and emerging markets such as ours, you'll often find that our establishing statutes, the statutes that establish the capital markets regulator, include an additional objective, and rightly so, and that is the objective of regulating for development of the market. Now, this is largely in recognition of the transformative role that markets play when in shaping economies. And so to this extent, the regulation has been drafted in such a way that it creates space for innovation. It is facilitative when it comes to development of new instruments and fast-tracking adaptability and being able to address or take up new opportunities that come in the market but doing so within a safe framework. And I dare say that without regulation, the markets cannot grow sustainably. So when you look at why do we need securities regulation, why does it matter? The simple answer is it matters because the market, which is essentially the investor, needs to know that this regulation, this safeguards, this safe framework is in place for them to participate and for them to earn what they are expected to earn in terms of their return on investment. What does this regulatory landscape look like across the 4 jurisdictions and 5, including Burundi, because it recently set up its capital markets? As I mentioned, we do benchmark against the IASCO principles. So by and large, you'll find that most frameworks, if not all frameworks, have adopted the IASCO principles in terms of being able to demonstrate this in their principal laws, but also in the subsidiary laws that operationalize the principal laws. And in this regard, you'll find that we have principles relating to the regulator around the independence and accountability of the regulator, the extent to which they are able to exercise their powers independently, the extent to which the regulations have a clear and consistent approval process. You'll also find principles around self-regulation, where from a market perspective, regulations are encouraged to adopt a framework where the regulatory system adopts the use of self-regulation with direct oversight for different areas of competence from the regulator, but by and large, promoting delegation of responsibilities to self-regulatory organizations such as exchanges. You'll find principles or guidelines that are related to enforcement of securities regulation. So the law is expected. And again, when we look at the 4-5 principal legislations across our region, you'll find that they are provisions on how the regulator can comprehensively inspect, investigate, and apply its surveillance powers. That is a specific construct of the principles from IASCO. You'll find framework around how the regulator can implement an effective compliance program, and that is around principles for effective enforcement. And there are other principles around cooperation, around issuers. I'll not go into them for detail, but I just wanted to give you a sense of what does the regulatory landscape look like across the region, and what is the common factor when it comes to our laws. And if you look at the IASCO principles, which all our laws ideally benchmark against to ensure that we are aligned with international best practice, this is where you land. And for a lawyer, especially practicing across different jurisdictions, and I'll make that point a bit later on, this is important because you know what to expect from a regulatory landscape perspective. You know that when it comes to enforcement, largely, this is what you would expect. At an operational level, there could be a few nuances per jurisdiction, but in principle, you'll find that the provisions, the overarching provisions, say, of enforcement, of cooperation, will cut across the different jurisdictions because we are all aligned or expected to align with these IASCO principles. Now, how does this law come alive? Because that is really what we're here to discuss. The law essentially comes alive when an issuer or a market participant structures a transaction. It could be an IPO, initial public offer. It could be a corporate bond issuance. You may look at a transaction maybe that is involving a merger or acquisition, or you may have a scenario, perhaps a more simpler scenario, where you're looking at an application for a license or an approval for a market player. And that is when the law really comes to life. You'll find areas around disclosure requirements which shape prospectuses. And as a lawyer, you'll have to go into the detail of, beyond attaching the document, is this document comprehensive? Does it actually speak to the disclosure? Does it satisfy the requirements of the disclosure? You're looking at attaching, say, valuation reports. Beyond attaching a valuation report, is it reflective of the fair market value, say, for instance, of the security that is proposed to be offered to the public? The trustee agreements that are attached, for instance, you've attached an agreement, but does it adequately capture the essence of the fiduciary responsibility that is expected of a trustee when handling matters, say, on behalf of investors? If we're looking, for instance, at a collective investment scheme scenario, when we come to the collective investment scheme industry. So why am I sharing some of these examples? When you look at the law, when you look at the text, it's pretty straightforward. You're expected to disclose this and attach this. But beyond the attachment, beyond the documents, the regulator actually goes into the detail of what has been submitted to ensure that it is not only accurate, but it is adequate in terms of the key areas that it is expected to address. Largely issues around liability, issues around full disclosure of the entire transaction, both in terms of what it is expected to deliver from an investment perspective, but also what are the liabilities that are attached to that transaction that is being proposed. And lately, we've seen mergers and acquisitions shape the insurance and banking industry landscape. And some of these players are listed companies. So we'll see applications, say, for instance, applying for, indicating that there is a person that wants to take up effective control and seeking exemption from giving a mandatory takeover offer. Now, just to give an example, across the 3 different jurisdictions, you'll find that our mergers and acquisitions regulations are more or less similar. You'll find that they provide for a definition for what it means to actually acquire effective control. Granted, we may have different thresholds in terms of what percentage is considered effective control, but in terms of the process, what is expected once you have made that intention clear, it's more or less the same. The public disclosure within 24 hours, but also if you do not intend to make a takeover offer, going through a process where you can seek an exemption. And then you have the criteria that the regulator will use to assess whether or not you meet that threshold. So what am I trying to say? Beyond what is written in the text, there is a process that goes on to interrogate the quality of the submissions that are supporting particular applications. And it is incumbent upon practitioners that are supporting these transactions to ensure that you don't only tick the box in terms of what you are providing to support various applications, but that those documents are foolproof, they're accurate, and that the information that is provided therein is adequate to persuade the regulator to provide the approval that you are seeking. And this brings me to my third insight. in terms of law in practice. And this is the regulatory approval process. What does this look like in practice? Obviously, as I mentioned, every transaction begins with an application, which is supported by detailed documentation, whether it's a prospectus, different agreements, the share purchase agreements, valuations, all these are reviewed for accuracy and compliance. Approval is not a rubber stamp. It involves rigorous scrutiny. Now, I know across the four jurisdictions, actually, that is Uganda, Kenya, Tanzania, and Rwanda, we all have a disclosure-based, we operate a disclosure-based regime. This means we primarily look at having satisfied the required disclosure as opposed to guaranteeing the commercial viability that is attached to the issue. But that does not go to say that where there is an outrageous statement made, say for instance, in the projections, the business plan projections, or anything that accompanies the application, we would not point that out. So the approvals are not to rubber stamp disclosures, as it were, and as they are provided, but it involves rigorous scrutiny for accuracy and for relevance and for completeness. Timelines are largely, which is one of the issues that I know is usually a pain point for applicants, they are largely dependent on the applicant. Oftentimes, you'll find that there's a lot of back and forth that goes into the application process, not only for issuances, but even for routine license applications, because maybe one or two items it has not been satisfactory, especially in terms of the content. So you'll find that there's a bit of back and forth. And on the part of the regulator, while sometimes you'll find that our regulatory frameworks provide for specific timeframes in some instances within which certain applications should be dealt with, we find that we've had to be flexible in order to accommodate certain market realities. And this process ensures integrity while enabling issuers, say for instance, access the capital they need. In practice, you'll find that the process has a cocktail of parallel applications. In most instances, you'll have an applicant that has a primary regulator for their industry, and so they'll need to get a no objection from their primary regulator. That takes time. Oftentimes, you'll find that an application, even where it's a license application, has a cross-border nature to it. So that will also take time in terms of ensuring that the applicant is in good standing in their primary jurisdiction. The third reality is technology. You'll hardly find any application that is not anchored on tech-enabled platforms to either achieve efficiency for service delivery or for it to make commercial sense. And so you'll find that a component of the regulatory approval process goes to assessing that platform, making sure that it's fit for purpose, making sure that the representations in the application regarding the technology or the platform are actually accurate. And then you'll also find that most applications, each application has a unique business case. And so you have to look at some of the simulations that are related to that particular business case for you to, as a regulator, to be able to make a decision on whether or not the application meets the requirements. Now, most of these things will not be stipulated in the law, but for you to, as a regulator, comprehensively review the application, you would have to go through this process to satisfy yourself that all these areas have actually been addressed satisfactorily. And this leads me to my fourth insight, which is balancing the law and commercial realities. How do we balance those unique business cases with the law, which sometimes may not be specific for each unique circumstance? Market players want speed, they want flexibility. Regulators, on the other hand, want integrity and compliance. And so the question of the day is always, how do we balance the statutory requirements with commercial innovation? How do we support innovation but without undermining investor protection? Because the balance is what keeps the market safe and also dynamic in a way. Because as they say, once bitten, twice shy. So you have to ensure that even as you're looking at these innovations, you're looking at the precedent that is setting, and you're ensuring that at no point in time is the investor protection undermined. So again, in terms of balancing the law and commercial realities, you'll find that across the 4 jurisdictions, our regulatory frameworks do provide for waivers. In a number of applications, they give the regulator latitude in certain instances to waive certain requirements, whether it be with respect to public offers, prospectus, the disclosure requirements, or whether it is in terms of license requirements. And so to a certain extent, this provides the needed balance between commercial innovation and application of the statutory requirements. As a practitioner, it's important to be aware of these waivers because this could be the only lifeline that your client may have when it comes to having their application approved. The duty, of course, is on ensuring that the request for the waiver, whatever is supporting the request for the waiver, is persuasive enough to meet the regulators, to satisfy the regulators' requirement or give them that comfort that it is indeed worth issuing a waiver. The second tool for trying to balance these commercial realities with the law, and our moderator aptly preempted this discussion, is the regulatory sandboxes. The regulatory sandboxes are now an affirmed tool of the regulator to ensure that we support new innovations while at the same time protecting the investor. So it's a space where innovative products can be tested under the full view of and participation of the regulator. We're able to identify the risks and recommend corrective measures within that space so that by the time the product or the service or the platform is going live, everyone is comfortable that it's going to, yes, activate the market, but it has the necessary safeguards that would actually attract new investors and preserve existing investor confidence. Across the 4 jurisdictions, I'm aware that Kenya had already had its regulatory sandbox operating for over 4 years now. I think last year, Uganda also launched its regulatory sandbox. and we've so far received about five applications, which are in the pipeline for review. I do believe there is a sandbox in Rwanda as well. I'm not too sure about Tanzania. I'll be guided, but this is just to show that this has now been an accepted tool, and it's really going to support it's reflects the regulators' approach towards ensuring that it is balancing commercial realities of which it is well aware under law. But again, going back to the point I made as I started to say that the law, the securities regulation, in part is aimed at supporting market development, particularly for emerging markets such as ours, where we have to tailor products and transactions to suit our own unique circumstances and economic realities. We are not able to do a copy and paste of some of these products, so it's important that we innovate, and as a regulator, it's important that we recognize that twist and support it. And then finally, in terms of facilitating this balance, is license conditions. You'll find that this is also a tool that is utilized by regulators to create that balance, because sometimes you'll find you'll never have, you can, but in most instances, it's rare to have an application that is 100%. Oftentimes you'll find, especially when it's a new area, either a new product or a young industry, the new applicants will be newly formed companies. So you'll find that there are some requirements in the law that they will not be able to meet. Things like audited accounts. You need to have been in existence maybe a year or so for you to have audited accounts. That's a simpler one. Maybe management structure. You'll find that an applicant is arguing that they are relying on the license to then go ahead to source for employees who would do the work, because without a license, they essentially have no business. And you cannot employ people when you have no business. So it becomes a chicken and egg situation. What comes first? Is it the license, or is it the fully fledged structure that the regulator is asking you to demonstrate as part of the requirements to giving you the license? Because on one hand, the regulator wants to know that you have a competent team to be able to deliver on the aspirations that you're indicating in your business case. On the other hand, it doesn't make business sense for you to have a headcount of so much. You're not making money. How are you paying them? You don't have a license. So being able to utilize license conditions on the go as a practical balance to getting some of these applications out and being able to support market growth and development is another tool that the regulator will use to ensure that it's balancing the commercial realities that come with emerging markets. And I think as practitioners who are supporting these processes, it's important that you're able to look out for these provisions and support the client when it comes to negotiating the license conditions that would, from a practical point of view, actually support them to get the kind of approval that they are looking for. And I'll go to I see time is fast running out for me. I'll go to my final insight. And this is really to share on practical challenges I think the challenge across the markets remains more or less the same. When you look at the markets, we have a liquidity issue. Most markets are shallow within the East African region, and in terms of being able to meaningfully support investors, but also meaningfully support issuers, as a regulator, we have taken a proactive approach towards investor education, and you'll see that across most of the markets, towards issuer education in terms of ensuring people know the value that they can unlock from the capital markets. This would ideally be a market participant role, but you'll see the regulator proactively taking on these roles because of the nature of our market and the challenge that remains around liquidity and the lack of participation within the markets. From a cross-border perspective, we do face challenges because we are still not yet there when it comes to harmonizing our regulatory frameworks. And so sometimes you'll find that there are instances where there are different requirements in the different jurisdictions, and that disrupts the lead time. For instance, if you were planning on a particular timeline within which to complete a particular offer, that may impact on meeting those timelines. So we still see harmonization gaps impacting turnaround time for various transactions. We have the East African directives for about 14 of them for the capital markets, which are anchored in the East African Market Common Protocol. And by and large, a number of jurisdictions have attempted to domesticate some of these directives in their national laws. However, we still see that they are being applied at different paces within the different jurisdictions. So sometimes that can be an issue, especially for the users of the market. Of course, regulators often operate with limited resources. That is both from a financial and manpower point of view. So that in terms of being able to meet the turnaround time that would make the client smile, your client smile, may be a tall order. But I do believe that this is something that is being resolved with adaptation of technology. A number of markets are looking at SupTech, that is supervision technology adaptation, combined with AI, and we see light at the end of the tunnel in terms of being able to cut turnaround time by more than half. And then there's the usual, the political and economic shocks that come, some of them external, out of our control, which realities impact our market. And as a regulator, the question is always, to what extent can you intervene to protect the investor when some of these incidents occur? I think by and large, the issue is to make sure that we are testing our markets for resilience. I think as individual markets, there's a lot of work that has been done to ensure market stability, crisis monitoring and testing. I believe what we need to elevate this crisis testing to a regional level, because oftentimes investors look at the East Africa as one market block. And so perhaps it is time to look at elevating that resilience testing to a regional level so that we are able to comprehensively say we can cushion the market, our individual markets, from these external economic shocks. But I think in closing, I would say these challenges remind us that regulation is not static. It must adapt. And we are looking at different regulations that are coming out just across the last year, and issues around digital transformation, automated reviews that improve efficiency are coming out, issues around prudential regulations are being strengthened. And so I think from a practitioner's point of view, these are all areas that you would look out for to ensure that both as you're preparing certain applications, they are top of mind because it is what the regulator is leaning towards. And then also just ensure that you're able to meet the requirements, whereas there may be no law in place for now, but from an international best practice point of view, you're able to demonstrate that whatever you're proposing meets that standard and that it can be acceptable. Patricia, allow me to end there for now. I thank the audience for listening to me, and I'll be here to take on any questions or clarifications.
Thank you, Alison. That was quite a comprehensive presentation. You walked us through the whole journey of regulation, and I can confirm that most of the things that you've said are accurate, having submitted several applications to regulators. But it's good to see what the AI, it's going to be interesting to see how you're going to do supervision with the SupTech. And we look forward to more engagements with you. To be able to protect the market. And it's also interesting that to note that you're all benchmarked by IOSCO. So if anybody today forgets what Alison has said, they should remember that all the capital markets seem to be regulated by the IOSCO. Thank you. Our next presenter is going to be Mr. Paras Shah. He's a managing partner for Bowman's Kenya, and he'll be talking about structuring capital, IPO, bonds, and private placement in practice. Parasha is a managing partner of Bowman's Kenya, which has now 110 fee earners. He specializes in mergers and acquisitions, capital markets, and financing work. As part of the Bowman Senior Leadership in Africa, Paras is a member of Bowman's Management Board and chairs the Farms Africa Committee. He has also played an important role in building and fostering economic ties with clients and ILFs in East Africa, the United Kingdom, India, Dubai, Japan, and Africa. Thank you, Paras, to talk to us about the IPO, bonds, and private placements in practice. Thank you. Welcome, sir.
Thank you, Patricia, and good afternoon to everyone who has joined this webinar. I am going to give a very brief overview about the kind of practicalities for capital raising, both debt and equity. Forgive me because mine will be twisted towards Kenya, because that is where I live and work, and that is what I'm qualified to speak about. But a lot of what I'm saying will be similar in terms of themes in the other East African states in which capital markets do exist. So briefly, I'm going to speak about the kind of landscape there is now. Some of this has been already covered. I'll then talk about equity IPOs, so equity capital raising, the structure and process, bonds, which is the debt side, some stuff on private placements, and then where lawyers come in terms of legal documentation, what are our regulatory considerations, etc. So to start with, in terms of the landscape that we face today, certainly whilst our capital markets in most of the jurisdictions, but in Kenya have been alive for more than 50 years, the real growth came in the early 2000s, after which there was a bit of a lull, and in the last 12 to 24 months, we are seeing rejuvenation of listings and general trading on the capital markets, certainly in Kenya. The NSE is very much the regional hub. It's the largest and most active exchange in East Africa, again, both for capital, for equity and debt capital. And the key regulators are the various capital markets authorities. My apologies to our Burundian colleagues, but their regulators should also be mentioned there. So the various capital markets authorities in each country and the stock exchanges in each country. What we have seen in the last couple of years is increasing sophistication in terms of regulation. So, for example, in Kenya, we have now seen a gold ETF listed. We've also seen a futures board on the Nairobi Securities Exchange. And most recently, we have seen the issuance of green bonds, as well as electronic and real-time trading on various platforms. And in the last large IPO in Kenya, which was Kenya Pipeline, we saw really interesting innovation in terms of how one can subscribe and trade for shares on the stock exchange by effectively from your mobile phone. I tried it myself. You can buy and sell shares literally 3 or 4 clicks. This is the ZD platform. So lots of innovation going on. It has increased awareness of the market. It has increased, to an extent, liquidity in the market, and certainly market awareness as well. The current wave of listings has been led by government, privatizing, for example, Kenya Pipeline. However, there are discussions amongst private players to bring other firms to the stock exchange, to the securities exchange. And we're looking forward to seeing even some private equity funds exiting their investments by listing, which to my knowledge hasn't really happened, certainly in Kenya. I think it's happened once in another East African country. Then lastly, there has been a lot of collaboration between the East African states. Ideally, there was talk ideally of having a unified exchange across East Africa. That has not yet come into fruition, but certainly I know there's a lot of collaboration between regulators and harmonizing regulations across the various jurisdictions. We already have had cross-listed companies for a very long time anyway. So the key legislation in Kenya, and again, similar regulations exist in other countries, but we have the Capital Markets Act and regulations, obviously the Companies Act, and then the NSE listing rules. Moving on to IPOs, which is an initial public offer of shares on the stock exchange. There are 3 ways in which a company can be listed on a stock exchange. There is first a traditional offer for sale, or as we call it, an IPO, where a company offers for sale shares in itself to the public to raise capital for various projects, whether it is expansion, paying off debt, I don't know, investing in a new IT platform or whatever. That's an offer for subscription. Sorry. And then there's an offer for sale where major shareholders offload some of their shares to the public by listing the company. This is classic for privatization, as we saw when the government of Kenya did that in the recent Kenya Pipeline IPO in Kenya, where a major shareholder sells its shares to the public. And then the last one is where there is no need for either capital raising or capital sale, or share subscription or share sale, and the company just wants to list on the securities exchange. This is what we call listing by way of introduction. There are reasons for this, for example, for a company to list for future capital raising exercises, or kind of more market penetration, or sometimes it is forced to do so by regulators, for example, in the communication sector. In each of these, pricing and allocation mechanics are absolutely critical and key. Pricing largely depends on market conditions. Often there is a discount offered to market when there's a capital raising exercise or capital sale exercise. And the allocation mechanics really depend on the objectives of the offer or the company, in that, for example, if it wants a large retail shareholder base, then the allocation mechanics are skewed towards that. If it wants a more institutional base of investors, then the allocation mechanics are skewed towards it. The key parties or key advisors for this kind of transaction would be obviously the issuer, the transaction advisor, which is typically an investment bank, a sponsoring stockbroker, which can also be the investment bank, reporting accountant, the lawyers, receiving bank who receives the money in the case of an offer for sale or subscription, PR, advertising, and the registrar who maintains the share register. I should mention that in addition to these, of course, the key regulators I've already mentioned, and the central depository system and the players involved in that are critical as well as key players in such an offer. The typical timeline for an IPO or listing is around about 6 to 12 months from mandate to listing, depending on what kind of company it is. It can be slightly shorter, but it really depends on what kind of company is being brought. The regulatory and approval process, the first when a company is considering a listing is to prepare the company for listing. In this, there are various considerations. There is the legal aspects. The company must be a public company. The articles must be tailored to it being listed. And one of the most important things in this is that all restrictions on share transfers have to be removed. Then there is the governance side. The company must prepare itself for proper corporate governance and compliance with the rules on that. This would mean typically reconstituting the board of directors of the company. It would need non-executives and independent directors. It would need to be ready for disclosures to the public, and really just be open to a lot more information sharing. All this requires a lot of preparation of the company, its board, and its key management. And then lastly is on the financial side. There's various criteria for this. Profitability, for example, keeping proper audited accounts, and various other kind of financial aspects that must be met. Typically, the due diligence will be done as the company prepares for listing for two reasons. One is to identify any key risk areas in that company, which would need to be highlighted to the public or indeed sometimes fixed before the company is listed. And the second is for disclosure purposes, to identify the key information that needs to be disclosed to the public as the company gets listed. After this, all the advisors put together will start the documentation and approval process. The documentation is central to this is the information memorandum or the prospectus, interchangeable terms, but depends on what kind of transaction you're doing. And there are prescribed disclosure requirements for these that you must very carefully go through with the company, and the company must ensure discloses everything as per the requirements. Our regulators are very much disclosure based, look at things very much disclosure based, and so this is a very detailed exercise that needs to be done when drawing up the prospectus. One of the other key aspects in the prospectus is risk factors. This is where the public must know or be told of key risks that face the company, both in terms of macro risks as well as micro risks, legal risks, litigation risks, etc., regulatory risks, etc. Once this is done, you then apply for various approvals, the key one being the capital markets authority who go through that document in draft form very carefully, and then there's a bit of back and forth, after which you get approvals, sometimes conditional, sometimes unconditional. I should mention before this, of course, the board and various shareholders of the company must also give their approvals as well. You must also follow the listing requirements of the stock exchange or the securities exchange and the conditions for admission. In all this, there's eligibility requirements, what kind of company can be eligible. And for this, there are kind of financial and legal criteria. For example, the size of the company, the profitability of the company, it's how many shareholders it should have, depending on the type of listing, etc., etc. Sometimes in a capital raise, a company might consider underwriting. This is where a third party, typically a bank, would come in and let's say a company is selling, I don't know, 4 billion shillings worth of shares. An underwriter would come in and say, okay, whether or not you manage to sell to the public, I will underwrite and guarantee that at least 2 billion shillings of those shares I will buy as the underwriter. The underwriter would then place these in the market at different stages. For this, there is a fee and a separate whole legal set of documents to be negotiated with the underwriter. And the underwriter then plays a very critical role in pricing, in what kind of information goes out, etc., etc. I mentioned earlier corporate governance requirements. There's a code in Kenya, certainly, and regulations in terms of how the company is governed going forward. This would mean how the board operates, who sits on the board, what kind of subcommittees of the board are mandatory. For example, an audit committee, a remunerations and nominations committee, etc. The independence of certain board members, etc. This is all critical, and the company has to prepare itself for that. And then there's the post-approval kind of allotment, refunds, and commencement of trading stages. And then finally, after listing, very detailed obligations on how the company can behave, what approvals it needs from shareholders, what disclosures it needs to make, etc., etc. I should mention, prior to, of course, going to market, there is a pricing discussion. This happens at a very late stage, just before listing, when together with the transaction advisors, etc., a company would decide on the pricing for the shares. This will depend on market conditions largely. So there's the approval sequence on the right: internal approvals, appoint advisors, diligence, and then the regulatory approvals. That was for equity issuances. Recently, there's been a lot of debt issuances by way of bonds or notes on the stock exchange, on the Securities Exchange, settling in Nairobi. The most common one is obviously government securities, which is bonds or treasury bonds. These are listed and traded on the Nairobi Securities Exchange. In Kenya, there's a separate regulatory regime for this, which sits under the central bank. And then we have corporate bonds issued by large companies. These are typically 5, 6, 10-year bonds, done either by way of kind of one-off bonds or medium-term note programs, which give a bit more flexibility. And then recently, we've seen green bonds or sustainably linked bonds. Kenya has certainly been a pioneer in this. Most recently, Safaricom issued a 40 billion shilling green note program, which was very successful. And in bonds, we have different players. Aside from the transaction advisors, we also have a bond or note trustee and paying agents who, through the life of the bond or note, would look after the interest of note for bondholders and make sure things are paid properly, and the issuer is held to account in terms of covenants, this, that, the other. The key terms for bonds, the tenor of the bond, i.e. how long, the duration for which the company is taking the debt on, 5 years, 7 years, 10 years, etc. The coupon, which is the interest that the company is willing to pay, which can be fixed or floating. Whether the issuance is secured. Sometimes it's secured by way of guarantee, sometimes harder security. Often in bonds, the company or the issuer will give very strict covenants as to what it can and cannot do. And some of these are financial covenants, so that it has to maintain certain ratios throughout the life of the bond. More than likely, the bond should be credit rated by a reputable credit rating agency. The reason why this is required is twofold. One is for pricing. Obviously, a bond which is rated much higher than another one will attract less interest, or rather will be able to, the issuer will be able to pay lesser interest. And the second one is certain types of investors cannot invest in bonds unless they're credit rated, for example, pension funds. And then there's sometimes more sophisticated instruments, calls, put options, conversion rights, etc. The framework for bonds, the documentation is slightly different. There is first a trust deed, then there is the information memorandum itself with the pricing supplement for MTNs, or medium-term note programs, security documents, credit rating documents, and sometimes even an underwriting agreement. And then covenants. Typical covenants are financial covenants. For this, you have to engage with other lenders. There's a negative pledge on making sure the company doesn't dispose of certain of its assets, for example, cross default, change of control provisions, and various information undertakings. It's important to mention in the context of capital markets, private placements. These can happen both for equity and debt instruments. So a typical private placement will be outside the kind of capital markets framework. So for very sophisticated, limited issuances of both capital and debt, typically to less than 100 sophisticated investors who will be investing quite large amounts of money, a company can issue on a private basis. You'd have to check your regulations to see what qualifies as a private placement. For this, you don't necessarily need capital markets type approvals, and the instruments are not listed in any form, but you'd have to comply with Companies Act requirements, etc., etc. Our legislation in Kenya also now allows for restricted offers. So these are offers to a small group of sophisticated investors. There's criteria for this. And there are approvals required for this, and these instruments are also listed, but there are exemptions from certain prospectus for disclosure requirements. This is increasing use of these is in growth stage companies, PE, VC transactions, etc., etc. The advantages here, of course, is speed to market, confidential. You have a more sophisticated investor base, costs are lower. And there's flexibility and kind of bespoke tailoring of terms. So what's a lawyer's role in all of this? Typically would be on the documentation side, as we've mentioned there, with all the documentation that goes with it. And then there's lots of negotiations with underwriters, with some key investors, sometimes with regulators, etc. There's due diligence to be done, and then typically legal opinions have to be issued in the main documents. And prior to all of this, of course, is helping prepare the company. And I talked about preparing the company for listing as well. I think this we've kind of gone over, but very quickly, what are the strategic considerations for bringing securities to the market? One, is the company ready? Is it mature enough, both from a financial, legal, and governance point of view? What you don't want is to bring a company to the market and the share price collapses the next day, or a major issue is unearthed the next day, and investor confidence then goes in that company or generally. So you have to be very careful about that. Market timing is critical. Sometimes you're ready to go to market and a macro event happens. For example, the Middle East war has happened that might affect a particular company, and you withdraw until the market stabilizes. Hand in hand with that, prior to this, your sponsoring broker or investment bank will have gauged investor appetite as well to make sure there's sufficient appetite to enable the success of the issuance. Obviously, the choice of instrument is critical depending on the objectives of the issuer, equity or debt or both. Pricing strategy. Here you benchmark against other similar companies in the region or on the continent or internationally, and kind of price accordingly, taking into account local market considerations as well. It's always good to have anchor investors, whether they're strategic investors or pension funds or other financial investors. Sometimes you might have cornerstone agreements with them where they get specific rights. A good example has been in the KPC IPO, where the government of Kenya got or rather KPC attracted a large investment from the government of Uganda, but special rights were given to them for that as well. And then managing the regulator and regulatory timelines, that's very critical. Considering whether you want to go cross-border or do a listing. Tax is really important, what implications there will be for investors. Typically, certainly in Kenya, there's no capital gains tax on selling your shares or stamp duty if it is listed on the stock exchange. But there could be taxes on interest on debt instruments, withholding tax, and so on. And if you're cross-listed, you need to check on the EAC as well, other countries and how that works. After listing, the company now is in a new regime of disclosures. So there's lots of continuous disclosure requirements. You need to be very careful and advise issuers of those. There's obligations on what the company can and cannot do, what kind of approvals are required for various actions. For example, a company cannot dispose of large assets without shareholder approvals and so on. It's really important to have things like insider trading rules in place to make sure that a healthy environment exists on the trading side. KYC requirements, etc. For investors, you'd have to very carefully know who your shareholders are or investors are, and constantly engage with regulators, investors, etc. As you remain listed. So there's lots of practical, commercial, legal things that a company needs to consistently look at. In Kenya, for example, the company also has to do audits regularly to satisfy the requirements of the CMA and other regulators as well, particularly on the governance side. So that's the end of my presentation. I think I've gone through these 6 key kind of areas which I've highlighted there. I'll be happy to take any questions if we have time, Patricia.
Thank you, Paris. That was a detailed presentation. It shows a wealth of experience. Thank you for that. And let's keep asking questions. To see Paris, you have to pay a fee. So ask questions in the chat box or in the Q&A. And let's continue to the next presentation, which is going to be done by Mr. Liduk Igabire. He's a founder and managing associate of Ron Proctor, a Bujumbura-based law firm in Burundi. He's a member of the Bujumbura Bar Association since 2016, and he's a writer. He's a man of few words, but today he's going to be speaking to us about disclosures, the risk and liabilities, what must be said, which are the mandatory disclosures, what must be managed. Those are the liabilities and risk controls and liability exposures. Welcome, Leduk.
Thank you, Patricia, for the warm introduction. And good afternoon to everyone. My presentation will be in 3 parts. Like you just said, Patricia, I'm going to talk about what must be said, meaning disclosure requirements. What must be managed, meaning risk management, and what happens when there is no compliance, meaning liability exposure. So about disclosure, this is a legal obligation. In the Burundian Capital Markets Act, it is stated that every authorized or licensed person must disclose material interests and facts relating to transactions they have entered into or in respect of which they provide advice in the course of carrying out capital market activities, including information relating to commissions and or other incentives received or receivable from any third party in connection with this transaction. So why is it so vital? The primary purpose of disclosure requirements is, on the one hand, to promote transparency, like my colleague Alison has already stated, and accountability, and promote market integrity. And on the other hand, the purpose is to protect both the organizations and the investors. So some of the missions of our capital market authority is to maintain market surveillance of capital to ensure fair, equitable, and transparent transaction of financial securities. So why transparency, accountability, and the market integrity are so important? Because they preserve trust and incite people to participate. Currently, like it has been tested. Stock market is far behind. We are still, building it up, and we need like competent staff, and most important, we need public awareness. And in order to do so, we have to have a transparent market. So because issuers, directors, or underwriters, and advisors in capital markets transaction must keep in mind that they are dealing with people's money, which is a sensitive matter. That's why there must be disclosure of material information, which constitutes any information that may affect the price, or securities, or influence investment decisions, like measures, staff restructuring, management changes, etc. Disclosure can be said initial, right before listing, through information memorandum, which contains complete information regarding the company's financial position, assets, liabilities, or prospectus, and other offering document by means of which the securities are offered to the public without prejudice to the provision of the law governing the capital market. Disclosure can also be said ongoing through periodical reports, through financial reports, operational information, etc. And how does this protect both the organizations and the investors? As lawyers, when we have a client and he or she, or when they have, they need the legal opinion about a specific matter, how to conduct a business, or reach a certain goal, we tell them what they need to know about what the law says, and what are the risks, what can be, how things may turn out. So this is the same with the organizations. They have to be transparent where they are going, what are their strengths, what they are working on, to ensure a mutual profit. So they need to be transparent and to disclose as much information as necessary. And this is on the other hand, for to allow the investors to have all the information they need to assess risks, know whom they are dealing with, and make sound investment decisions. So disclosure must be timely, accurate, and equally accessible from everyone to ensure a fair trading. Now, what must be managed? Now we are talking about risk management. We can't discuss of capital markets without thinking about Mr. Warren Buffett and his tremendous impact on the market. So one of his his two investment rules are: rule number one, never lose money, and rule number two, never forget rule number one. What does this mean? It means that potential losses must be identified, assessed, and controlled in the best way possible. And this is the core of the market. When people invest on the stock market, they expect to make money. And gaining money can only mean that someone else lose money. So also volatility is the name of the game. What goes up come ultimately down and up again. So that's how it goes. Now we are talking about market risk, which can be through price fluctuations, currency risk, as my colleague Paras just pointed out, liquidity risk, like my colleague Alison has already pointed out, credit risk, operational risk, interest rate risk, regulatory risk, reputational risk, because brokers are expect to be paid through management fees and percentages on the profits. And the best ones know how to mitigate those risks and strengthen their reputation. It can be through diversification. It can be through diversification is mixing stocks, bonds, and commodities in order to avoid putting all the eggs in one basket. It can be through hedging, a strategy to limit investment risks. Investors hedge an investment by trading in another that is likely to move in the opposite direction. Tonight is a big match day for the Champions League, and I know we have audience from Uganda, Kenya, maybe Rwanda. And I know there are many Arsenal fans there, so they can think like, we don't know if we can bet any longer, or I don't know, on this team. Maybe on the other side, Atletico Madrid, his best scorer, Antoine Griezmann, he can wish to give the best for his last campaign with the team, and fans can be tempted to bet on both teams. And this is an example of hedging. You reduce potential loss while maximizing returns. It can also be through stop loss orders, which is automatic sell order at a specific price level to cap potential losses. It can be through proactive management and to avoid credit risk, or internal control and to avoid reputational risk. But as it has been pointed out earlier, modern risk management now relies a lot on data and mathematical models, like value at risk calculations, scenario planning, documentation, and compliance through more clarity, manual rules and procedures, and also continuous monitoring. Money never sleeps, even when the market is closed. And AI now is able to provide real-time monitoring systems, which can give an instant alert when there is risk to lose money, or when a certain pattern is identified. It can also be, through stress testing. So now the last part of my presentation, what happens when there is no compliance? Now we are talking about liability. So disclosure must be, as I said, timely, accurate, and equally accessible from everyone to ensure fair trading. When disclosure fails to meet the deadline, talk about material omission, like omitting critical information such as a loss of a big contract or staff restructuring, management changes, etc. And when disclosure is not accurate, when the information is not accurate, we are talking about misstatement, which is a false, inaccurate, misleading statement, acting as a deviation from the truth. When disclosure is not equally accessible, we are talking about inside trading. Our Capital Market Act states that every now about the management, when there is poor management. Our Capital Market Act states that every authorized or accredited person is liable to customers and other parties who have entered into a contract with them for any act of negligence, recklessness, and or fraud committed by them, and any act of negligence, recklessness, or fraud committed by their representatives, employees, or authorized agents arising from a failure to implement adequate internal controls. So this can there can be civil and criminal penalties to be enforced for providing misleading information and failing to meet disclosure deadlines. And yeah, that's that. I will take any questions when the moderator will deem it necessary. Thank you, everyone.
Thank you, Leduc. We've learned a bit about the capital markets in Bujumbura and especially about risk and liability and disclosures. So thank you for that. Anybody with questions, kindly ask the questions in the Q&A. Our next speaker is going to be Sheila Kiki Matano. She's an accomplished legal counsel with over 10 years experience doing cross-border transactions and managing legal risk across Anglophone Africa. She has expertise in structuring bankable capital markets, project finance, corporate finance, and infrastructure deals with a focus on regulatory and policy. She's an advocate of the High Court of Kenya and a certified secretary. She's an in-house counsel across various market-leading organizations, and she has worked with organizations like DLA Piper, Shelter Africa, Akon Holdings, and Construct Africa. Thank you, Sheila. Welcome. Let's hear about your presentation. Her presentation is going to be about REITs and legal and tax frameworks. Thank you. Welcome.
Good afternoon, colleagues. Sorry, Patricia. I was trying to share my screen and at the same time introduce myself.
No problem. Take it away. It's all
Okay,
yours.
great. Thanks, Patricia. Good afternoon, colleagues. My name is Sheila Kiki, as has been mentioned by Patricia. I will be taking you through my presentation today, which will cover REITs, basically real estate investment trusts. That is the legal and the tax framework. I will attempt to share my screen. Please let me know once it appears. Okay. Can you see my screen, Patricia?
Yes, we're good. Thanks. We can proceed.
Okay. Great. So I'm told that I only have 15 minutes to make my presentation, and I am cognizant that there's one more speaker, so I will try to limit myself to the 15 minutes. If there are any questions and/or thoughts, I am happy to receive, and we can take that during plenary. So to start us off, I think it's important for us to set the takeaways from this session. And the first takeaway would be to pose a challenge to everyone, which is for us to sort of pivot from thinking about real estate as the typical brick and mortar, and for us to start thinking as asset-backed securities. So if you forget anything else from my presentation today, is to pose a challenge to yourself and ask yourself, as either in-house counsel or practitioner in a law firm, are you thinking brick and mortar or are you thinking asset-backed securities? I will go straight into my presentation again because these are slide decks. They just have speaker notes, and I will try and expound. So the first question, what are REITs? So as I began, REITs are real estate investment trusts, quite a mouthful. And REITs essentially work to pull capital from investors to help promoters and/or help say I'm trying to not use capital markets parlance, but sort of the people who structure REITs to give them capital, which essentially, instead of having one person who is, say, a business owner try to get funding, either equity from themselves or debt, it gives the avenue or the platform for them to just pull in money from particularly institutional investors. But as we've seen recently, even in Kenya, retail investors, although for that the uptick is still quite slow, but is coming up. So REITs typically, and this is from as Kenya perspective, as Paras had said, I'm also I practice in Kenya, and as much as my training is in common law, I am limited to my practice within Kenya. Although I will attempt to draw parallels because, as Alison had said during her presentation, the regulatory framework is more or less similar across the region. So while we delved into REITs, REITs can either take two personalities or two legal personas. What is commonly known is, particularly in East Africa, is the trust base, which is a unit trust. And the unit trust, the constitutive document is a trust deed. Obviously, there are other supporting constitutive documents, which are known as scheme documents, and these vary across the board depending on the service providers that you have. So you could either, and we'll delve into that when we talk about the different types of REITs. So you could have a development management agreement, a property management agreement, a shared services management agreement, which essentially governs services that are used across the board, say fumigation, say things like security, Wi-Fi, which allow you, for example, if it's Wi-Fi, to buy in bulk and then distribute across the assets or the properties. And then what we see as international best practice, which mostly is adopted across the United States, which is a corporate model, and it could take the form of a limited liability company or a limited liability partnership. I think something important to note under the legal persona, in as much as we have in the East Africa region a trust-based approach, your underlying assets would typically be held by a special purpose vehicle, what we call an SPV, and you do have leeway in structuring of the SPV, either to have it as a limited liability company or a limited liability partnership. As in-house counsel or as lawyer advising a REIT promoter, then I would say that you would need to confirm with your tax framework whether to take on an LLP or an LLC or LC structure. Obviously, in Kenya, if you take on the LLP structure, there's a myriad of exemptions, tax exemptions, which are not just nuanced to REITs, but also to LLPs, and just to also ensure that the structure is being as risk remote as possible. So your SPVs, which are the asset owning entities, can either be an LLP or a company. Before we go into the sector diversity and asset types, I will mention that usually REITs will take on two types, which is either a development REIT, which is known as a D REIT, or an income REIT, which is known as an I REIT. In East Africa, I'll talk about the successful REITs. So on the side of successful REITs, so far we have two listed development REITs. They are both under a promoter known as Acorn Holdings Limited. And Acorn, particularly in Kenya, are more known for their product, which is Kwetu and Kijani, which is a purpose-built student accommodation. But they've also just last year listed one development REIT for young urbanites, which is essentially accommodation for young adults who are transitioning from college into the workforce. There are other, obviously, D REITs, which are at the moment being structured, hopefully will be coming into market towards the end of the year, which are not necessarily residential, but would also cover commercial. So we delve into the sector diversity. Whether you have a D REIT or an I REIT, you have the leeway to structure and to play within different sectors. You could play within the resi, which is the residential, or you could have the commercial. Under the commercial, it could take on different types. You could have logistics and warehousing. You could have also you could have niche, which right now there's only one player in Kenya, and they're sort of trying to do data centers. You could also try do telecommunication towers. You could try and do hospitals. Outside of the East Africa region, hotel REITs are quite successful, particularly in Mauritius, because they ensure the longevity and or sustainability of hotels, as opposed to having one person or say one entity running. The amount of money that you're able to pull from the investors is able to help you keep the assets sustainable, ensuring these ESG things to do with water, things to do with power. So you sort of take on renewable energy. You can tap into sun, you can tap into wind, you can tap into nuclear, although nuclear hasn't been done, but I do know across the board solar is being used, not just in the hospitality industry, but also in PBSA and in the residential. So we spoke about the development and investment REITs. I will try take you through the life cycle so you can understand the distinction between the development and investment REITs. So for the life cycle of a REIT, you begin with, sorry, just give me a moment. You begin with the asset origination, obviously under the regulatory framework in Kenya, which is the Capital Markets Act, but more particularly the capital markets, again, the regulations are quite a mouthful, which is the Capital Markets Real Estate Investment Trusts, Collective Investment Schemes, regulations of 2013. You are required within a period of 180 days for you to have what we call a seed asset. Your seed asset should have an investment value of not less than, they've given an investment value of 100 million. So you have your asset origination. For this asset origination, typically what they require is for you, it could either be land, or it could be, say, a building that has just been put up, but hasn't, say, you've not ramped up occupancy. Or it could also take, say, a building that already has occupancy, but you sort of want to reposition it. Say it was offices, you want to turn it into residential, vice versa. So you have your asset origination in the development REIT. If we're taking, say, a greenfield and we're putting up a building, it would then mean that you put up the building, you ensure that you've gotten all the approvals and the permits, and then thereafter you warehouse it. So what is warehousing? Essentially, it's where the entity, say the REIT manager and or the owner of the REIT, keeps the asset within the ecosystem of the business to ramp up occupancy. And usually for this, you require a stabilization threshold. And stabilization essentially means that you have occupancy running at a minimum of 75% for 3 months. Not on average, you have to ensure it's 75% and above. What does that mean? The reason why we warehouse and stabilize is so that once the transfer from the development REIT to the income REIT has been done, then you are sure that, one, because more often than not, the D-REIT has taken on debt, is to ensure that the monies that is coming from the revenue that comes from rent receivables goes into paying off. And even at the point of sale to the income REIT, the money that they receive, the consideration from the income REIT can go to pay off. So nobody would want to take on, say, a building or an asset that has low occupancy levels, because it means then that it negatively impacts the revenues of the owner. Then the next we've spoken about in the life cycle, asset origination, warehousing, and stabilization, then transfer to the IREIT. The next is the income distribution. I will not speak about income distribution at this point. We'll talk about it towards the end, so we can also look at the tax framework around distributions. Now, again, within the regulations, you can convert your D-REIT to an I-REIT and an I-REIT to a D-REIT, although conversion for I-REIT to a D-REIT is very restricted, but the regulations have provisions for this. Okay, the operational ecosystem. So I will attempt to speak about the legal and regulatory framework, which essentially will also highlight the players within the REIT ecosystem. In Kenya, as I said, the overarching law is the Capital Markets Act, and then we've spoken about the REITs regulations. But depending on whether you're listed on the main bourse, or which is known as the main segment, or whether you're listed on a sub-segment, will determine the regulations and or the operational guidelines that will apply. So let me point out that remember when we were speaking about sector REITs, I will take you back to this slide, and we talked about the logistics REIT. So we have one, the new kid on the block, which is the ALP REIT, which has been listed on the main bourse. But for the PBSA, which is the Acon D REIT and I REIT, they are listed on a special segment, which is known as the unquoted Securities platform, USP, which is a platform on the Nairobi Securities Exchange. And essentially the distinction between listing on the main segment and on a sub-segment, there's several considerations. On the sub-segment, for example, you enjoy the privilege of your, when we talk about par value, particularly for companies, in REITs, we talk about the net asset value, which is the value of one unit. So the par value, fortunately, when you are on the sub-segment, the net asset value is determined not wholly by, say, the demand the demand between players, say sale and purchase of units within a REIT, but is determined by the valuation, which is done biannually, and is also determined obviously by macros and micros, but you do have I would say leeway to sort of determine the net asset value, as opposed to when you're on the main bourse, which is then determined by the uptake and or the market. Forgive me, the word seems to elude my mind, but it is as opposed to being determined by demand and supply, then the NAV is determined by the matters that we spoke about. The valuation is determined by the dividends, is determined by the uptake, the rent escalations, the uptake by rental uptake, ramping up of occupancy levels. So again, if you're listed on the main bourse, obviously you would need to comply with the regulations that are for all entities that list public listings. So there's a regulations, which is the capital markets, again, a mouthful, offerings and public listings regulations. But if you are on the sub-segment, you would comply with the unquoted securities platform operational guidelines of 2020. And at the same time, you would also comply with the capital markets, corporate governance, market intermediaries regulations. I will need to point out now, when we speak about the various players within a REIT ecosystem, that the capital markets licensing requirements, the general regulations, we do have a 2025 regulations, which have repealed the 2002. So where you are advising any players, you need to be keen, because there've been a couple of changes, say even in the application fees, the supporting documents when you're making applications. So the different REIT players, we've spoken about the regulator, the Capital Markets Authority, and then we have the REIT trustee. Usually the REIT trustee takes on, in Kenya, a lot of them, well, two of them are banks, which is the Cooperative Bank of Kenya and NCBA. There is a third one, but those that are used in the market are either COP, which has been in the market quite long, and NCBA, which got their license, I think, in 2024. And the reason why you'd have as a bank is because a trustee is required to have a minimal capitalization of 100 million, just to ensure that unit holders stroke investors' money, if say the bank were to go under, they're not commingling the funds of the bank and the investors' money. Their role essentially is to hold assets and to be custodian. It stops there. Obviously, there are Chinese walls where they play as the trustee, but as we'll see later in the current trends, sometimes there may be conflict of interest. The third player is the REIT manager. So the REIT manager sometimes can be a subsidiary of the promoter, and the promoter is basically I'd say the person, the legal person that is sort of the owner of the owner of the REIT. So this is the person who would at the onset underwrite the structuring costs, which include a transaction advisor, legal advisor, either a reporting accountant, which would also, again, if it's on the side of the IREIT, and because the service providers, depending on whether it's a development REIT or the IREIT, you'd also need to have a structural engineer. You'd also need to have a project manager certifier. So those would be the people underwriting the costs. Again, you can bring on anchor investors who would underwrite that cost. But that's just a matter of structuring and also how deep a promoter's pockets are. So like I said, REIT manager could be a subsidiary of the REIT promoter, or they could just be a separate entity altogether. Again, there's certain considerations. If you are looking to have a separate REIT manager, obviously you'd look at the track record in terms of governance, in terms of even the performance of the REIT under their tenure. Then lastly, as I said, whether it's a development REIT or an IREIT, you could either have the asset manager or property manager. Again, the terms are used interchangeably, but do not mean the same thing. An asset manager is in the strict sense of the word. They look at the asset to ensure, number one, the asset is returning or is making returns for the investors. And a property manager is similar to what you'd have, say, and when you're staying at home, say in an apartment or if it's a townhouse, it sort of works like a management corporation, or essentially they look after the common areas, ensuring that there's wear and tear is being taken care of, etc. Whereas an asset manager does more than that. And then for a development REIT, you definitely need a development manager, and this is the person who is mandated to engage the main contractor, that's the MC, the subcontractors, ensure performance bonds are in place, etc. And they're also the people who ensure that all permits, approvals are in place for the time that construction is ongoing. Okay, I think we had spoken about acquisition and warehousing. But again, we'll look at acquisition when we're doing the transfer from the DREIT to the IREIT and how we would be treating the tax element thereunder. So remember when we were talking about listing either on the main investment segment or on the restricted segment. So I attempted to sort of show the distinction, and we'll take it from the top. So where it's on the main segment, you do have the retail and professional, and then restricted, you have only professional. Again, at the point of structuring, I'll say this. The regulations or the regulatory framework only gives you a basis for structuring. It does not spell out that you are restricted to the proviso. I'll give a perfect example. So under the REIT regulations in Kenya, obviously, it talks about when you're making your offer, that you make your offer to professional investors. And in the recent past, they've brought down the threshold, which was a parcel size. And parcel size essentially means a ticket for investment. The minimum previously was at 5 million. It's now come down significantly to 100,000. Obviously, just to ensure that there is more participation from retail investors, but you have the leeway to define who your professional investors are or your sophisticated investors. Again, the regulations spell that out and they give a test for that. And you can say your minimum parcel size would be maybe 10 million, depending on the risk appetite of your anchor investors. In terms of compliance threshold, we spoke about this, the full public listing. Paras had mentioned some of the things, to do with audits, to do with how you structure your committees. Again, your trust deed would spell out your investment policy, and then all other documents thereunder would spell out what your governance will look like. Obviously, you are required to have a corporate governance committee. Why? Because regulations speak about connected party transactions. When we were speaking about the different service providers, a development manager and a property manager can also be subsidiaries of the REIT promoter. So you do want to show arm's length. And that's why you put together a corporate governance committee. Again, the test is under the regulations, just for them to confirm that the test of arm's length has been met, such that if it's the development manager, because they will be charging development management fees, and a property manager will charge property management fees, just to ensure that that is being done above board. Again, if you're on the main segment, you would have to comply with the full public listing rules. Minimum capital thresholds, again, in as much as this is indicated as higher thresholds, remember for REITs, entry into the REIT market can sometimes feel restrictive in that there are very few people who are able to raise amounts at that level. And also sometimes investors tend to be risk averse, particularly in certain markets, maybe where, say, real estate, the uptick isn't as much, particularly if it's outside of institutional investors, say pension funds and things like that. So the risk appetite may not be as high. We've spoken about NSE and the USP. I will not belabor that point. So I had mentioned we would look at the tax framework. This is very important. And I would like to lay emphasis. I'd made a mistake on the non-resident investors indicating a 15%. That should be 10. So under the corporate tax, one of the reasons why any person who plays within the real estate market would want to structure a REIT is because you are corporate tax exempt. That's, I would say, the greatest impetus to structure a REIT. So what does that mean? At the end of the day, whatever your corporate tax is, whatever your total revenue is, there is no tax if you are operating a REIT, whether you're operating a D-REIT or an I-REIT. Then the next one would be stamp duty. Post 31st December 2022, stamp duty was scrapped for REITs. It was there. We're hoping under the finance bill in Kenya, the 2026, that this will be reinstated. Again, because remember, if you end up paying stamp duty as a REIT promoter, then you will the stamp duty eventually will be offloaded or taken up by at the point of when you are putting or determining your rent. So where there is stamp duty exemption, it helps to also just align with affordable housing. Then when it comes to VAT, this accrues on commercial assets. I will give an example. Remember, we said for a development REIT, you can acquire whether it is greenfield. Sometimes you can acquire when it's brownfield. What do I mean by brownfield? Say you've acquired a lot of land, that is a parcel of land, and what is there is a single dwelling home, and you want to bring it down to multi-dwelling. Sometimes you can acquire a lot that has commercial for purposes of putting up resi. If it's a commercial, even if you try and bring down the building, VAT on a commercial asset will still accrue. And VAT is quite steep in Kenya. It's at 16%. So when you look at the overall land cost, which may range between 100 million Kenya shillings to say 350 million Kenya shillings, which is equivalent of $1 million to $3 million, and then you add the element of 16%, that's quite steep. And where you've ended up having VAT, how you can circumvent this is you can have the person that you're acquiring the property from, in as much as you're required to pay the VAT, you can have the transfer being done in phases as opposed to all at once, so that you're paying at the VAT accrues at a minimal amount. Again, that's up to your external counsel or in-house counsel in terms of how you're structuring that. Then when we talk about dividends, I'd mentioned this earlier. Obviously, investors require dividends. Under the regulations, you're required for the development REIT, it is not a requirement or essential or obligatory that you declare dividends, but for an income REIT, you are required to declare dividend. And dividend, the base case provided under the regulations is once a year. Again, you can do it biannually or whatever other frequency. Of course, this is determined by the profit that you make, because dividend is paid out from the profit. So as the REIT promoter or the REIT manager, together with the trustee, as you're paying the dividends, again, the REIT manager is the one that recommends to the trustee the dividend distribution. So resident investors would pay 5% and non-residents would pay 10%. I'd said apologies for the 15%. Okay. Now, I would like for us to look into the market challenges and trends. So for the market challenges, again, this Alison had spoken about this, which is basically alternative investments within the region aren't performing as well, obviously because government tends to give higher risk-free return. And so fund managers would opt to lend to the government as opposed to investing in alternative investments. In as much as the Retirement Benefits Act provides that up to 30% of their capital can be allocated to alternative investments, you find that when it comes to when the rubber hits the road or when the rubber meets the road, the allocation is at a much lower because one, more often than not, the fund managers may not necessarily think that REITs or real estate would be bankable, and or maybe the pipeline of bankable projects isn't as wide as they would like. And even when it comes to a variety, say commercial, logistics, etc., there aren't as many players in the market. But this is a very big challenge because REIT promoters then are left with really not much of an option. Their fundraising, if it's not concessional, say with the DFIs, it ends up being commercial. And because it's commercial, it has a negative impact on the distributions to the investors. And because it has a negative impact on distributions, when you are fundraising in the market, you find that over time, say within between 3 to 5 years, at the onset, there may be appetite, but once you reach or you hit the 3-year mark, the 5-year mark, you find that fundraising is increasingly difficult, and even the ticket sizes are smaller because then you end up having your revenues, a lot of it is being hived off to pay off debt. So if there is any money in the room listening to this, I would be interested to hear your thoughts on how we can circumvent that challenge. Alison had spoken about creating market awareness, but I think it goes beyond creating market awareness, but just the goodwill as well to deepen the capital markets in our region. So that's I would say, the biggest challenge, and I mean this as I am a practitioner within the REITs market. So I understand the pain points. In terms of trends, so there's a trend I hadn't put here, but it's a food for thought, and there are two, and they center around the trustee. Now, trustees typically, we said they are corporates and they're banks. So what you would have is banks would second their directors to form the board of trustees, so to speak. But over time, you realize, that these trustees may not necessarily have the capabilities, say, on valuation of real estate assets. They may not necessarily understand, say, if you're operating in a particular segment. For example, if you're operating, your asset type is in hospitality, they probably have know-how on hospitality. If it's data centers, they have no know-how on data centers. So one of the things that we are trying to do is to include independent. One of the approaches to the capital markets is to include independent trustees on the board. Now, these independent trustees would come in, obviously, to plug that skill gap. That's the first. But the second, because the trustees are usually banks, as I had said, what comes to mind is a conflict of interest, particularly where the parent, which is the bank, is also a lender to a REIT. So they are double-hatting both the lending business and the trustee business. And therein lies not just a perceived, but a real conflict of interest. So an independent trustee would come in to mitigate that risk. And usually, even under the regulations and international best practice, what is recommended is to have an independent being the chairperson, and to also have them as the chairperson of the board and also the chairperson of the investment committee. The other trend within the market is to limit the term, so term limits for the trustees, a maximum of 9 years, just to ensure that there's still accountability, because you don't want to end up having the trustees, they become a bit too familiar with the product. And so even sort of like the feedback that they're giving may not necessarily be as useful as it were at the onset when you're structuring the REIT. I think the other things, this is for players within Kenya. Just give me a second. Yeah, so for the players within Kenya, I would like to highlight particularly that there's a new building code, which is the 2024 building code, has been rolled out. So any REIT players looking to acquire property, obviously as part of their due diligence, particularly on the income REIT, may just hit you with the due diligence covering the new building code, and you wonder, gosh, what does this mean? Does it mean that the value of the property or the asset has come down? There's certain things, obviously, that you can try and bring the building up to code, particularly with things like the fire exit. There's certain dimensions that are required. If, for example, you have your windows, there's certain should I say girth of the windows that you need to have. So and this is not just for REITs. Anybody who is within the real estate advisory across Kenya is something that they need to be aware of and to start to adopt that. The other one, obviously, is incorporating ESG. Everybody, there's all hullabaloo about sustainable finance. And one of the ways to ensure, and it's not just hullabaloo, Paras had spoken about green bonds. Obviously, by the time you are raising a green bond, there's certain things you need to have EDGE certification. You need to have the GRESB benchmarking. This go a long way in ensuring that if you are looking to tap into green financing, that's one of the easier ways. So ESG is not just the environmental. We've discussed the governance. Obviously, for the social, some of it would cover, say, who are the demography represented within the assets that you've acquired, either male or female, persons with disability, etc. And then I think one thing I need to mention for EDGE certification. So whilst you are pursuing EDGE certification, you can have an interim and a final. And what I mean by interim is at the point where you are putting up the building, you can still pursue your EDGE certification, so that at the point of completion, now you have your final EDGE certification. That also helps, particularly if you've gotten debt, commercial debt from a local bank. It will also help with the metrics, the reporting metrics when it comes to green financing. I will pause there, and I will end by saying that when we began, we agreed that we are moving from brick and mortar to asset-backed structuring. And this is just to encourage anybody who wants to, be an advisor within the capital markets, REITs particularly. There is a wealth of opportunity for you. It may feel insurmountable because the regulations are quite expansive, but you can only learn by doing. And there's also, when it comes to just the structuring, it expands your view because you get to apply different branches. It's not just real estate. You look at capital markets, you look at governance, you look at corporate finance. So this is a great opportunity for all colleagues across the region to practice and to also reach out. I will share my email with the EALS, Capital Markets Committee. I'm happy to guide, hold your hand, and to just help to deepen the markets, the capital markets in East Africa. Thank you for your attention, and I welcome questions during the plenary session.
Thank you, Sheila. That's what you call passion, huh? Passion about treats, passions about where we are. Thank you for the great presentation. Sorry to everybody, we've run out of time, but we will give our last panelist 10 minutes to do his presentation. Kindly bear with us. In the next, by about 4:20, we should be closed. Sorry about this. It's all about passion. Thank you. So our next presenter is going to be Luis Namwanja Kizito. He's a business and commercial lawyer. He's a partner at Pentagon Advocates. He's very passionate about technology. And today he's going to be talking to us about regulation, innovation, and market evolution, the future of capital markets. Kizito, take it away. Thank you. 10 minutes. Thank you.
It's less than that, actually. Patricia, can you hear me?
Yes, I can. Thank you.
I anticipated running into running into overtime, so I deliberately prepared a paper. I think it's about 20 pages of my views and presentation, because I am not going to go into the nitty-gritty and I'm not going to dot the T's and really cross the T's and dot the I's on this issue, because I know people are already tired. But I am just going to, under really 8 minutes, I'm going to explain what I have in that write-up. And for anyone who wants to have a deeper self-reflection on what I'm just saying, what I'm going to say, we'll actually have time to read the paper and maybe even reach out in case there are some concerns or some modifications. So just briefly. All right, Patricia.
Yes.
I just proceed with my presentation. The best part is my presentation has been circulated with, I think, with the CEO, the Secretariat, so it can be distributed. So for me, let me get down to it. I was trying to look for it, but I can't get it off. Right. So okay, this is supposed to be a forward-thinking segment of the discussion. That is why I think I was made last, and I think I'm going to put some thought-provoking arguments for not only the regulators in this space, the lawyers, but also the policymakers largely. The kind of capital markets regulation we need in East Africa should demonstrate a healthy tension between helping companies acquire and access our capital markets with ease and less regulatory unnecessary burdens. And also, we should also have, on the other hand, robust investor protections. Now, we can't do one at the expense of the other. We have to create that balancing act. And I think in our region, we have largely not done that. Of course, macroeconomic factors have much to do with our small capital markets, but also the regulation and the market plumbing, the one I'm actually going to discuss more in this presentation later on, because I'm also going to look into the areas of blockchain rails and how securities can be minted in a blockchain native way for custody and so the delivery versus payments in that space. So having said that, when I read the East African, for I think last week, there was a story that was detailing that 40% of the investor pools within our capital markets in this region, East Africa, it is largely foreign. So 40% of our investor pools are foreign, and that actually really, given the macroeconomic and geopolitical shocks, and given that our markets are small, that has a bearing on pricing. It has a bearing on also market shocks. Out of suddenly, we can actually have those market shocks. So, having said that, I think we need globally competitive, locally relevant regulations. I pointed that out in my paper. Like I said, I'm really summarizing what I'm saying. I don't want to go overboard. Now, in my paper, also, our paper rather, we made a few recommendations. Because most of our businesses in East Africa are family owned and they don't want to really relinquish themselves to the control of investors, maybe we could explore dual class shares. According to market practice and according to the rules of exchanges in much of the region, actually, I think all the rules, you cannot list dual classes if you're a company. So you have to amend the articles, the memorandum of association, to reflect one share class, which is actually one share, one vote. But given the fact that our businesses are largely family owned, I think we should have more flexibility and see whether it works. Even rigid jurisdictions like the Hills Review, I call upon most of our people here to read the Hills Review. The Hills Review is a report that actually was commissioned, I think, by the Treasury of the UK to look into capital markets reform in the UK. Now, the UK and the London Stock Exchange is predominantly a very rigid, not as flexible as New York or even Asian counterparts. It's rigid in terms of its rules and admission to the official list on the London Stock Exchange, but it's actually also looking into dual class shares. Now, that should be introduced with caveats, some caveats. Why? We can have a maximum weighted voting ratio of maybe 20-1, where those shares are weighted and held by directors and are only executed in a few circumstances. So that calls upon the rules to be changed. Now, going back to the larger discussion we're going to have, the other recommendation I also made, we are looking at, because this again was meant to be a forward-thinking session to show us or to explain where we're going. We should create a separation and this is a legal issue, it's not even a rules-based issue on exchanges. We should create a separation between the concept of offer of securities to the public and the concept of shares that are admitted for trading on an exchange. Let me explain why. It is common in our region, in East Africa, to have a 6 to 8 weeks roadshow that precedes a listing. That's what you call an IPO with a prospectus and an eventual listing. The reason why this discussion is important is that we should know when a prospectus should be needed. I'll give you a good example. In the market in Uganda, we had Bank of Baroda doing a bonus issue. Now, everyone on this call, at least majority, know that a bonus issue is an internal corporate action, basically. Yeah? It is not a capital raising event that warrants a prospectus. So the reason why it's important to separate offer of securities to the public and then subsequent listings, that they don't always go together. And for instance, I might be a company, I might have a client who has a company that's already listed on the exchange. Maybe they want to do a bonus issue. Now that we're in the fintech unicorn-driven world, maybe want to grant some employee share option schemes. Why should I offer a prospectus for something that's not a capital raising event? And then also, we're entering the world of digital ledger distributed DLT financial instruments that are securities. Now, it doesn't matter whether the underlying rails are blockchain based. A security is a security. And according to global practice, and the US gave us a Howey test. So if something is on the blockchain and it is security, it's a security. Now, in the world of security token offerings on chain, you may not require that entire roadshow of 6 weeks and then the subsequent listing that happens after. So we should be a bit more forward thinking if we are to have our markets grow. And then this is going to be a point that I also should stress. Capital markets regulators are conduct-based regulators. And I've had this engagement with our regulators in Uganda, and I think it's a work in progress. I think we shall end up being on the same page at some point. I'm saying this because the way assets are held in the capital markets is different from how they're held in the banks that are regulated by our central banks. When I put a deposit in a bank, liability. And how is that liability safeguarded as a deposit? Capital requirements, financial type requirements, prudential requirements. it is warranted. Now, in the capital markets, and I'm glad one of the presenters has actually gone into things like the REITs and even an earlier presenter was presented on the direct listing. Now, in the capital markets, unlike the banks where we have liabilities, where public money is held as liabilities, we're dealing with assets under management. Now, how you regulate assets under management is more of a conduct issue than a prudential and financial type regulation issue. Why? Because the assets that are owned, the assets that are held by capital markets participants or brokers are not liabilities and their assets under management, and they don't even reflect on their balance sheet. So what is best regulated is conduct. The only reason, and IOSCO is also very clear on this, IOSCO stipulates when financial type regulation or capital requirements are needed. They are needed when you can demonstrate a risk that you're trying to mitigate. I'll give you a very good example. I was very young in the early 2000s. But from what I'm reading up on, Kenya's capital markets, and I think one presenter actually, I think, hinted on this. The Kenyan capital markets were booming in the early 2000s. But because they were accompanied by certain fraudulent intermediaries, like brokers, and the Capital Markets Authority of Kenya actually introduced regulations, financial type regulations. What that has done 20 years after it was promulgated in law is that now you have a shrinking Kenyan capital markets space. You get? So my plea is capital markets basically are assets under management models, and you only actually primarily regulate conduct. But if you're going, I'll give you an example. Exchanges don't hold assets. These are order matching engines. Okay, they match orders. And so if there are no assets at the exchange, then why the capital requirements? So for me, and I'm going to conclude with the market plumbing issues. This is my last submission. For those of you who want my detailed submissions, you'll find them in the paper. I've shared it with the Secretariat and my co-panels via their email. Now, I'm going to go into the market plumbing issues. This is my last thing to discuss. What is market plumbing? Market plumbing is the hidden infrastructure that enables Lewis to get access to assets in the capital markets. Now, in the mainstream public markets, we have depositories, and in most of our countries, we have undergone something called dematerialization of physical share certificates. If your company is listed on the stock exchange, the MEMATs, as a lawyer who has been hired by the transaction advisor to take the company public, we are told to actually amend the articles to reflect that there will be no physical share certificates, but a digital entry and a book entry will be conclusive evidence of ownership. That is settled. Now, I went into something called delivery versus payment, which is a settlement mechanism in the capital markets. And let me explain it quite very simply. And this is my final word. Please don't really get tired. If I'm going to buy OCBK, okay, to buy a bond at auction, what happens is that I pay first, I give the money first, then I get the security later after a day, T+1 settlement. Now, blockchain-enabled rails, and thank God that Kenya has passed the Virtual Asset Service Providers Act. Blockchain-enabled rails make it possible to have atomic settlement, where if Lewis pays for a security, he gets that security there and then and doesn't have to wait for a day to get settled. So that's the element of atomic settlement. Now, blockchain-enabled rails, and I'm going to give an example. The New York Stock Exchange has now announced an automated trading platform, an ATS, where they will actually make the security. They have 24,000 securities that they have available on the exchange to be tokenized in the next 10 years, because the Trump administration has also really been friendly to the Web3 rails. And then the NASDAQ, which is the second biggest stock exchange in the world. I'm using these global examples because that's where we want to be. And that's where we can be. I don't want to use Kenya because in Uganda, we have copied and pasted so much of Kenyan legislation, and I've just given you the context. So the NASDAQ stock exchange has a rule was approved. A rule change was approved by the SEC of the US to offer tokenized securities. Now, this is also an issuer-based choice. Okay? And also, additionally, the DTC, which is the custodian for US equities, has made available their platform, and they've got, I think, a no action recommendation from SEC, the Securities and Exchange Commission in the US, to largely make available the shares or the securities they have available for tokenization on the blockchain rails, permitting real-time settlement. And if you want to understand more of those things, please read my paper. And then lastly, I'll conclude with this simple statement. In a world where our exchanges are not competing within themselves alone. When, for instance, the Uganda Securities Exchange is only competing for businesses in Uganda. I have been advising quite a number of growth, or rather highly scalable startups that are venture capital backed. They end up getting listed in New York, not even in Johannesburg, or even sometimes in Dubai, London, because of the market plumbing issues I'm talking about. Of course, liquidity issues. Nigeria, we saw that Dangote wants to do a multi-country IPO. In my view, it can't happen because Nigeria doesn't have the framework for cross-listing. The way we have a working arrangement within the East African, the ESC. Because in Uganda, the MTN offered shares, and I have clients who literally in Kenya they bought shares because the CMO of Kenya did a no objection for the roadshow to go on. So our exchanges are not just competing for businesses in Uganda or in East Africa. Even the unicorns we are coming up that are coming up in East Africa will actually end up listing in London, in New York, and Jumia is a good example. Jumia its market is primarily African, but in 2018, I think I just left university. It actually chose to list on the New York Stock Exchange because of all these liquidity issues. I'll give you an example. In Uganda now, we have tax exemptions for private capital, what you call private equity and venture capital. That is not enough because for private capital to work, you need what you call strong network effects. Everything needs to align at the same time. Why do you have to exempt a venture capital fund when the person who's going to be granted employee stock options in a startup that has raised money at a certain valuation is going to be taxed highly because of those employee stock options? So you grant employee stock options to the venture capital fund, and then the management team and the team that is on ground to make sure this highly scalable startup actually keeps the wheels rolling and grows and scales and becomes the next big thing. Their compensation packages are highly taxed. So what we're now seeing, we are seeing corporate inversions, even despite of the progressive tax arrangements in the private capital market space. Corporate inversions because of we don't have what you call strong network effects. You do not give one advantage and then you ignore the other disadvantages that are in the market. So with that, I'm going to conclude. I had a lot to say about order matching engines, about SPACs, special purpose acquisition companies, and how our rules on exchanges in East Africa have rebuttable presumptions that are dangerous for SPACs and how they are impractical and how we can change them. So all that can be found in the document. Thank you very much for hosting me today. And I don't want to keep our guests waiting. Thank you.
Thank you, Kizito. That was very passionate. Thank you. Sorry you didn't have a lot of time to cover this, but you've done well. You've really done well. So to our guests, if you have any questions, please forward them to the ELS. They'll be able to, the panelists will be able to answer them. We see the questions. I don't know if Paras is still here or he has left. Kindly give us insights on the Safaricom bond that your law firm did. What were some of the key roles and objectives involved in advising Safaricom? There's another one. What is the standard legal fee charged for IPOs in Kenya? That can vary. I don't know if Paras is here. And if he's not, you will get your responses from the ELS. Thank you so much for giving us more time. It was all about passion. You can see that the panelists were very passionate about their respective topics that they were covering. And we see that over 20% of you cited new CMA licensing and recapitalization deadlines as your top concern. That's a perfect way to end our session today. Legal compliance is no longer about rules, as you've heard from the panelists. Rules are important, but as the regulator said, when they are approving applications, they dig deeper. They dig deeper into that. So it's also about the financial health and survival of the firm. So as we close today's session, remember that the law firms that will thrive in 2026, especially in the capital market space, won't be the ones that follow the law only. Yeah, but they will be the ones that master the practical applications of these complex frameworks that you're talking today. The navigating the 2026 ESG regulatory landscape will just not be about reading the CMA circulars. It requires a proactive shift in law as we manage data, capital, and risk. So let's take these challenges as a roadmap for our next steps in ensuring our markets remain both compliant and competitive. Thank you for joining this session today. We will share the slides that have been shared by the panelists, and enjoy your afternoon. Thank you for joining. Asanteni sana and goodbye. Thank you, panelists. We can log out.
Thank you, Patricia. Have a good one.
Well, thank you, Alison. I'll see you when I come to Kampala. Bye.
Sure. Bye.
Okay, bye. Kizito, bye. Mushiri, bye.